Alrighty, folks, looks like we are live. I'm George, one of the founders of SoloSuit. Let me know if there's any issue with the audio or the visual. Well, it looks like you should be able to see me and hear me okay. So happy to be here. We're going to be talking about how you can be sued, can you be sued for credit card debt? All right, so we're going to be talking about that, whether or not you can be sued. Short answer is yes, you can be sued. Many of you folks here have probably been sued for a credit card debt. So if you weren't aware of it before, you're probably aware of it now that yes, you can be sued for a credit card debt. Alrighty. Looks like we have a lot of questions here in the chat. If you have a question, go ahead and put that into the chat. We take most of the time just responding to questions from our wonderful audience. So if you have a question, just go ahead and put that into the chat. Little disclaimer, I'm not a lawyer, I'm not your lawyer. SoloSuit's not a law firm, we're not your law firm. We don't provide legal advice, this is just a webinar that we're doing. You should probably consider hiring an attorney at some point in this journey. And there you go, happy to help you guys out. Just, let's see. Just in short, if you've been sued for a credit card debt, then you can use SoloSuit to respond. A lot of people are looking at how to settle their debt with portfolio recovery associates. So we're also going to be dealing with that, okay? So if you have been sued by portfolio recovery associates, potentially for a debt lawsuit, or a credit card lawsuit, then you can do quite a few things to deal with them. Okay, let's a common question that people have is, what is portfolio recovery associates? Portfolio recovery associates is one of the biggest debt buyers in the U.S. They buy a lot of debt and then they try to collect on it. Oftentimes, right? I mean, oftentimes they're doing this pretty well and respectfully, working with consumers to collect this debt. They oftentimes will buy the debt from like a credit card company, let's say like Discover Bank or something. They might buy debt from them. They'll buy a huge portfolio, usually for about 4% of face value, and then try to collect on it. Okay, just because they bought the debt for 4% doesn't mean that they are going to settle for that amount, or that they should. They need to get significant return to stay in business while they're collecting. So we help people manage their expectations, and we also build trust with the collectors, and we help folks come together somewhere in the middle to get a reasonable settlement. Okay. Should I pay portfolio recovery associates? Yeah, generally, if they have a valid debt that you owe, you should probably pay them. Okay, if you've been sued for the debt, then you first will want to respond to the lawsuit to assert your rights, make sure that you aren't taken advantage of somehow in court. Okay, once you do that, you can make an offer to settle. You can do both of those things with SoloSuit. You can use SoloSuit to create a response document and file that in court. You can also use SoloSettle, our debt settlement marketplace, to connect with the collector and get to settlement terms that you both agree to. Then you'll sign the settlement agreement on our app, and you'll transfer the funds to the collector through the app. In this case, that'd be Portfolio Recovery Associates. Okay. Another question, how can I resolve a Portfolio Recovery Associates lawsuit? Okay, so yeah, so if you've been sued, right, just going through those steps, okay, so you can create the response on our software, and then you can make an offer to settle. That's how most people want to resolve it. If you feel like you don't owe the debt, then you probably shouldn't pay it, right? If it's a debt that you don't recognize, then you should not pay. You'll want to get more information on the debt. It happens with quite a bit of regularity that like the wrong person's sued, or they've already paid the debt, or they're not the one that actually owes the debt, or the debt amount is wrong, right, etc., etc. All of those kinds of things happen. So you want to protect yourself and only pay a debt if it's actually yours. Okay, and once you do pay a debt, there's lots of benefits. For example, your credit score will likely go up, right? If you have a delinquent debt or a lawsuit or a judgment on your credit report, all those things are going to really harm your debt, your credit score. And once you pay it off, if you pay it off completely, it'll show as paid in full on your credit report, which will be much better on your credit score. It'll be more less detrimental to your credit score. And then if you settle it, it'll show settled on your credit report, and that also will be less detrimental to your credit score than having a judgment or an open lawsuit against you on a debt. All right, great. Those are some basic questions. Getting into basic questions that I've answered here. Getting into some of the questions here from the audience, I'm going to go ahead and jump right in. Alrighty. So we got Regina. I want to settle an old debt on 2 credit cards that Portfolio purchased and have on my credit report as collections. I want to get off my credit. In total, they claim $2,000. Should I offer a settlement? Alright, Regina. So it sounds like you want to settle 2 different credit card debts with PRA, Portfolio Recovery Associates, and they're on your credit report right now. You want to get them off the credit report. So they're claiming that between the 2 accounts you owe $2,000. Should you offer settlement? Yes, sounds like this is a pretty ideal situation for settlement. If you've been sued for these debts, you'll want to first file an answer document, and then you can offer settlement. Okay, so use SoloSuit to create a response, and then you can make an offer on SoloSettle. We settle debts with Portfolio Recovery Associates with some regularity, and once you settle it, it'll show as settled on your credit report. The debt won't be totally removed from your credit report. I mean, these open lines and stuff remain on your credit report as well. But your credit score will likely go up once it shows it is settled. If you're being sued for $2,000, then a reasonable place to start is like $1,000. If you have more money and just want to get it done with, you can make an offer for the full amount. You can go 75%, 70%, whatever. With most debts we see settle for about 70% of the balance. That is the average. We see debts settle all over the place, but the average is 70%. All right, moving on to a question from Sunny. Portfolio says I owe them money. I responded, I have not signed any agreements with Portfolio showing that I do. I asked them to provide me signed documentation that shows my agreement with them. Should I try to settle? Okay, so again, this is Portfolio Recovery Associates. Sunny's saying that they say that Sunny owes them money. He said, I haven't signed any agreements with you. And then they asked to provide me signed documentation that shows my he asked them Sunny asked PRA to send him documents showing that he owes them the debt. Okay. So Sunny, in this case, PRA bought the debt from someone else. So there is no single agreement that will say you owe PRA money. How it works is they'll have a credit card agreement that was in place when you got a credit card. Let's say you got a credit card with Synchrony Bank. They'll have that agreement, and then they will have a record showing that Synchrony Bank sold and assigned the debt to PRA, giving PRA the right to collect on the debt. Right, so that's what they will have, and this is totally a valid legal situation. There's really nothing invalid about this arrangement. It's totally checked out in court. It's totally fine. The issue that you can poke holes in if you want to go this route is you can continue to say that they have the burden of proof. It's required legally for them to prove that they have the right to collect the debt from you and that you owe the debt. And you can say that the documentation is incomplete. All right, let's say they don't actually have the original credit card agreement that you e-signed or signed by consent. Let's say maybe they don't have the document showing that Synchrony Bank sold the debt to PRA. So those are like valid points that you can bring up as a defense here. Alrighty. And that said, yeah, settlement is probably going to be the best route. It's more than likely that PRA does have those documents. Maybe they don't. Definitely sometimes these collectors do not have those documents. But if you do believe that you owe the debt, settlement's going to be the best path because it's on your credit report, right? So if you do owe the debt, it's probably on your credit report. The only way to get it off is by settling it or paying it in full. Settlement's the cheaper way to go because instead of paying the full balance, you're only going to be paying a portion of the balance. And again, maybe you can get them at a 70% settlement. You can also get them on like a monthly payment plan, right? So if you don't have the money all up front, when you settle through SoloSuit, you can offer a monthly payment plan and just pay the debt amount, the settlement amount plus our commission over time on a monthly payment schedule. Okay, moving on to a question from Frank. Can we use a consumer finance protection class action suit against PRA as a defense against them with a judge? There was a settlement against them twice. An interesting line of action. Right. So you're saying PRA has been sued twice by the CFPB for a class action lawsuit alleging that they harm consumers in some way. I suppose, yeah, it's a good question. It's a good question. I suppose that you could bring that up as evidence in a case showing, alleging that like PRA has bad faith or something when they're collecting, or that they likely don't have documentation that you owe the debt. It might be considered like irrelevant by the judge, but maybe it's something that would be worth bringing up. No harm trying it out if you want to. And there you go. It's probably not like a line of reasoning that will get you closer to a settlement if you want to aim for a settlement. But it could be interesting if you're already planning on going to court. It could be interesting to bring that up. All right, moving on to a question from Caesar. Hi, can we touch base on wage garnishments and court preparedness? What do you say? What do you ask? Okay, yeah, so wage garnishment and court preparedness, those are two different things I would say. So first talking about wage garnishment. So if you lose your case and you don't offer to pay the debt immediately after losing, the collector will then most likely file for wage garnishment in your state. So they'll file probably what's called a writ of garnishment, and that'll give them the right to garnish. Once the court rules on it, that'll give them the right to garnish your wages. They'll then send the document to the employer. They'll have to find out who your employer is, and they'll send the document to your employer telling the employer that your wages are being garnished, and then the employer will send the garnishment amount out of every paycheck. That'll send a check directly to the collector, and then send you the remaining amount. The federal maximum for garnishment is 25% of your wages, generally, or like your reduced wages, like your livable wages. So it'll probably be some amount, probably quite a bit lower than 25% of your wages, of your gross income. And then that's how the garnishment works. If you try to avoid garnishment, or you refuse to tell the collector who your employer is, they can just file a document in court, which will require you to provide the information to the collector. Okay, so that's not really much of a valid path, but you can certainly make it difficult for the collector if you want to. All right, so that's garnishment. And then court preparedness. The main thing for court is to remember that the requirement for the collector to win is for them to prove that you owe the debt and they have the right to collect on it. So all of your arguments should go about disproving that, right? You'll want to bring documentation. If you have documentation showing that you paid the debt, you'll want to bring that with you to the court. You'll want to, whatever the real story is, you just want to figure that out beforehand. Probably make a binder for the case, have everything printed off, show up in court. Okay. So that's the general idea. That's the general idea there. Okay, moving on. We got about 5 minutes left, so I'm going to try to do a little bit of a lightning round here. Okay. Take a look at Spinster Cat Lady. What happens at motions hour in court? My attorney is filing a counter suit for an FDCPA violation, and I'm wondering how long this will drag out and at what point an agreement is typically reached. Okay, not a whole lot of that made much sense to me. I'm not super sure what we're talking about here. Motions hour, I don't know. Sounds kind of like happy hour at the court. I have no idea what motions hour is. Maybe it's a time where you come up and have a hearing about a motion that was filed in the case. Also, I'm not sure why your attorney would be filing a countersuit for an FDCPA violation. If you're the consumer, you're probably filing an FDCPA violation against the collector. So I'm not sure what the countersuit would be. I suppose you were being sued for the debt, and now your attorney's filing a countersuit alleging an FDCPA violation. I see. So yeah, those can certainly go on for quite a while. The collector is probably going to force the attorney just to proceed all the way to the end with the countersuit, I would imagine. If not, maybe they'll settle at some point in time before that. Totally depends on how long it's going to take. Probably not less than 6 months. Probably not more than 3 years to see the end of this thing. But it could go on for quite a while. Alrighty. Peter, how do I stop PRA from reporting false information to credit bureaus? They fail to mark the account in dispute and will not. Okay, that's problematic. You want to file like an FCRA dispute letter with the credit bureau, also potentially with the collector. Probably want to communicate that with the bureau themselves. At some point, if they really aren't doing it, then you can always sue them for violating the FCRA. And oftentimes, these things just really take a lot of time. All right, let's see. Ashelsa, a firm opened the case against me in 2021. I answered the complaint, never heard from them again. Now they are back in 2024. Same case number, is that legal? Plus my name has changed. Yeah, this is probably legal. You probably won't win or resolve this on a technicality. Even if it was illegal, the case would probably just be dismissed, and then they could file a new, dismissed without prejudice, and they could file a new lawsuit against you. But you can certainly, bring up the issue with the court. Usually, cases don't just end if they don't do anything for a while. Sometimes they try not to do anything for a while, hoping that you'll move or something, and then they can wrap up the case without you knowing. Okay, so yeah, so you just want to proceed, probably want to settle this case just to get it all fully wrapped up. All right. Sarah, how do you remove off of your credit report once you settle? So the collector should mark the case as settled on the credit report once you have settled. If they don't do that, you can send them an email requesting that they do. You can send an FCRA dispute letter to them, also to the bureau. You can just kind of make a racket about it and get it removed. You can also hire a credit reporting agency, a credit building agency. You can look through some of our old webinars. We have some credit repair folks that we work with, and you can check those out, and they'll have tips or they can do it for you. All right, last question here. Do you have a debt validation letter sample? Yes, I believe we do. If you check our blog for debt validation letter sample, you'll be able to find one. You should also be able to see it on the debt validation letter page. I believe in the FAQ, there's a sample listed there. And yeah, you can just try generating the debt validation letter. You can also just pay for it and generate it on our site. If you don't like it, we can always refund you. And there you go. But it really is a great bulletproof debt validation letter. Very extensive. All right, folks, this has been fun. That's all the time I have today. Again, I'm George with SoloSuit. Wish you all the best. Please remember, we are in your corner. We are fighting for you. We want you to win. And we are here